Good afternoon, Your Honors. This is case number IT-0588/2. The prosecutor versus Zdravko Tolimir. Thank you.
And since these are the last sessions, I would kindly ask the prosecution for the appearances.
Good afternoon, Mr. President, Your Honors. Peter McCloskey, together with Kweku van der Puye, Rupert Elderkin, Abir Hassan, and Janet Stewart.
Thank you very much. And for the defense?
Thank you, Mr. President. My name is Zdravko Tolimir. Together with me is my legal advisor, Mr. Alexander Gajic. Thank you.
Thank you very much. Mr. Tolimir, very briefly, I told you yesterday, if there is anything which causes problems for you, health problems, you should indicate that to the chamber immediately, and you may request a pause, a break, so that you are able to conduct your closing arguments properly today. Because of the delayed start, we will consider if you need, no, I should put it in a different way. We gave you 1 day, like the prosecution yesterday, for your closing arguments. We lost 15 minutes. We will see how it develops today. And we still have the opportunity to have rebuttal and rejoinder arguments by tomorrow, so that you shouldn't feel under pressure, time pressure, by giving your oral submissions. Mr. Tolimir, you have now the floor for your final oral submissions.
Thank you, Mr. President. I would like to greet everybody present in this courtroom, and may God give you all the blessings for all the good deeds that you are going to do. May God's will be done in these proceedings and not necessarily mine. Once again, thank you for the good communication with me. In the third amended indictment, the prosecutor presented a lot of accusations against Tolimir and tried to corroborate those by speculative documents without any factual basis. At the very beginning, I have to say that the series of accusations that have been presented in the final brief were not present in the third amended indictment. However, since they're not founded, I do not need to defend myself by pointing to the facts that were not contained in the indictment. In the proceedings before this courtroom, in order to consider the facts as being established based on the indictment, they have to be proven beyond reasonable doubts. And the defense doesn't have to prove anything. It is the prosecutor that has to prove. The prosecutor has to prove both the objective elements of all the charges that are contained in the indictment, as well as the subjective elements of the crimes, the mens rea and the knowledge which is required for every crime. Criminal responsibility is always individual, and all the facts have to be considered exclusively within the context of individual and subjective responsibility. In his final brief, the prosecution starts with the thesis, according to which Tolimir was one of the closest advisors and the person of could the accused be asked to slow down? It is impossible to follow.
The chamber wants to listen carefully to all your arguments, the interpreters asked you to slow down, otherwise they are not able to translate properly. Please read your text a little bit more slowly, so that everybody can follow.
Thank you, Mr. President. After the break, I will try to provide the interpreters with a copy of what I'm reading, and I apologize to them. The accused assumes criminal responsibility of General Mladic, which was never proven and was not a matter of trial in these proceedings. The fact that during the war, Tolimir was the assistant commander of the main staff of Republika Srpska for intelligence and security cannot serve to draw any conclusions about the criminal responsibility of Zdravko Tolimir. The idea of a court trial is to establish the truth, and this is something what the defense tried to do throughout the proceedings. However, that was not the case with the witnesses who struck a deal with the prosecution.
Read slowly, the interpreters can't follow. And if you have hard copies of your presentation, it could be delivered now with the assistance of the court usher to the interpreters in the booths. That would be very helpful. Mr.
I have instructed my advisors to make those copies, and they will do it with your leave, of course.
With the assistance of the court usher, that can be...
We have one copy now. Thank you. Those witnesses have presented a series of...
And you should continue until during this period when this matter is resolved, but please read slowly.
Thank you. This refers to the testimonies of those witnesses who presented a series of lies without any proof, charging other persons, primarily Momir Nikolic and witness PB057, who testified as viva voce witnesses, and then also Deronic, whose contradictory testimony was adopted according to Rule 94 bis. In these proceedings, we heard a number of members of UNPROFOR who were deployed in Bosnia and Herzegovina as peacekeepers. As a matter of fact, they actually contributed to the prolongation of the war, and they acted in favor of BiH army. Let me remind you of the testimony that the trial chamber heard. For example, witness Petar Škrbić on transcript page number 18649 testified that he attended a meeting which was also attended by Tolimir and Commander of NATO for Europe, Admiral Dayton Smith, who said that the role of NATO was to establish a balance of powers between the army of Bosnia and Herzegovina and Republika Srpska. If NATO representatives didn't hide that fact, today those who contributed the most to the implementation of that policy don't want to talk about that, and they are the representatives of the command structures of UNPROFOR. The way the role of UNPROFOR is presented today is best corroborated by the Dutch Institute for War Documentation, which is partly in evidence in this case. I'm referring to P610, paragraph 2, in which it is stated. Although it was stated differently in the public, the lawyers of the Royal Dutch Army prepared Dutch witnesses for testimonies and carefully examined their statements with the approval of Colonel Karamans. The paragraphs have statements which may have opened some issues were deleted or reworked. At the end of the day, the Ministry of Defense and the prosecution did not pay attention to the Dutch battalion, but to Karadzic and Mladic. End of quote. False reporting happened during the war in the territory of Bosnia and Herzegovina.
Sorry for interrupting. We want to have a clear and correct record. I think there is one mistake, and we would like to clarify that. On page 5, line 8, there is a reference to the commander of NATO for Europe, Admiral Dayton Smith. I don't know if that is correct or if that is incorrect. Perhaps you repeat the name again.
I apologize. The name is Admiral Leighton Smith. Thank you.
Thank you. That clarifies it, and you should continue.
The false reporting that was happening during the war in the territory of Bosnia and Herzegovina was something that General Smith mentioned in one of his statements at D192, and I quote, "Commanders sometimes submitted false reports to their superiors when they didn't want to hear things." End of quote. One of the problems during the war in the territory of the former Yugoslavia was the question of the enclaves, which had been proclaimed demilitarized and protected areas, and nevertheless they were used as military strongholds. This was not only the case with Srebrenica and Žepa, but also with other enclaves, for example, Gorazde and Bihać, which effectively served as a NATO army, which became very prominent during the NATO aggression, the Army of Bosnia and Herzegovina and Croatia against the Republic of Serbia with the help of rapid reaction forces. Without understanding the context within the developments happened during the period of the attainment, it would be impossible to see what the role of NATO and UNPROFOR was. I am referring to D324, page 2 in Serbian and 3 in English, and this is actually the statement by the officer of Dutch BAT, Van Dijn, who provided that statement before the commission of the Dutch parliament, and I quote, "There was no peace there. However, we were told to maintain that peace as best as we could. It was a political order to monitor how both sides maintained that peace." End of quote. The prosecutor charges Tolimir with participating and contributing to the implementation of 2 parts of joint criminal enterprise: forcible removal and killing of males in Srebrenica, and based on that, in the 3rd amended indictment, it formulates 3 charges. None of the allegations which could serve as the basis for the conclusion of criminal responsibility based on the facts which can be proven with beyond reasonable doubt in these proceedings. The prosecutor charges Tolimir with the participation in the alleged criminal enterprise whose alleged goal was to forcibly remove and deport Muslims from Srebrenica, and I quote, the prosecutor says that Tolimir largely contributed to the implementation of the joint criminal plan of the participants in the joint criminal enterprise, end of quote. In that, the moment when that alleged criminal plan was conceived, according to the prosecution, was the 8th of March, when the directive of number 7 was passed in 1995. The prosecution also emphasizes the important role of Tolimir in drafting of that directive. However, the prosecution did not prove the concrete participation of Tolimir in the drafting of Directive 7. Tolimir was not in charge of writing it, nor was he involved in the wording of that directive. He played the role that in all the armies of the world is assigned to the assistant commanders for security and intelligence. Could the accused please be asked to slow down when reading? It is impossible to follow.
Tolimir, the interpreters again asked you to slow down. They can't follow. And we want to have everything what you have to say to be reflected on the record. Please read slowly.
Thank you, I apologize.
A sastoji se u dosta
And that role consists in submitting information about the enemy and proposing measures of intelligence and security support in keeping with the relevant regulations. As is stated in the final brief by the prosecution in paragraph 164, I quote, Mladic received proposals with regard to those elements of the directive that concern that area, their areas of work or their sectors, and if those elements were adopted, they would be included into the final version of the directive, end of quote. In the parts of Directive 7 which refer to the intelligence about the enemy and the intelligence and security support, there is nothing illegal. What is written in the parts of the directive in which there is information about the enemy and its intentions has been shown as completely truthful and was useful in practice during the war and after the war. Directive 7, in its challenge part, which concerned the task of the Dreamer Corps, was never changed. The directive number 7 itself, which was passed on the 8th of March 1991, and which was passed by Commander Radovan Karadzic, was soon replaced by Directive 7/1, which was issued by the commander of the main staff of the Army Republika Srpska, General Ratko Mladic. In that directive, there is no reference to the creation of unbearable conditions for the civilian population. The prosecutor talks about all the actions that have to do with the enclaves and ties them with Directive 7, including the alleged restrictions on the humanitarian aid convoys. However, in the relevant part of Directive 7, it is stated, and I quote, daily planned combat activities to create conditions of total uncertainty, end of quote. Delivering humanitarian aid is not a combat activity, therefore it is not comprised by Directive 7. Let me remind you, Directive 7/1, which was passed soon after Directive 7, is completely in keeping with the rules of international law of war, and the role of Tolimir again consisted in submitting intelligence about the enemy.
In paragraph 199 of its final brief, the prosecution claims that the purpose of Directive 7 was to deprive the population of Srebrenica and Žepa of the supplies that they needed for survival and thereby to cause a humanitarian catastrophe. However, there is no mention in any of the directives of this intention, nor is there any evidence that the VRS deprived the population of the bare necessities. If the prosecution speaks about the so-called ostensible restrictions, this kind of restrictions envisaged by Directive 7 could not in any way be conducive to depriving the population what they needed for survival. The evidence presented in this case demonstrates that the humanitarian convoys reached the enclaves even during the period when attacks on the army of Republika Srpska were launched from these enclaves. There was one convoy scheduled for the 11th of July even, which indicates that there was no planned activity for the capture of Srebrenica, but the plan was to separate Srebrenica and Žepa and to have these enclaves demilitarized. As one of the elements of the so-called JCE, of the removal or deportation of the civilian population of Srebrenica and Žepa, alleges the purported restriction of humanitarian convoys. In paragraph 60 of the indictment, as well as in their final brief, they say, and I read, Tolimir imposed restrictions on UNPROFOR and humanitarian convoys, unquote. The allegations about so-called or purported illegal activities as presented in this case are not accurate and are not based on the established facts. Therefore, I assert that truth has to be established in every trial and that it cannot be based on what was being served as the propaganda apparatus of UNPROFOR and NATO. We have to make distinction between UNHCR convoys because their main purpose was to provide food for the population of Srebrenica. However, on more than one occasion they were abused and the commodities were delivered to the BH army in the enclaves. As for UNPROFOR, the purpose of these convoys was to deliver food and material for the needs of the UNPROFOR within the enclaves, and they had nothing to do with the situation of the civilian population. As demonstrated by the evidence presented here, UNPROFOR was also involved in providing ABH army and material. The totality of the evidence presented in this case, it can reasonably be concluded that both types of convoys were intended to create conditions for the army of BH to be able to conduct offensive actions from the enclave in order to tie up the territories of the enclave with the central territory of the army of BH. First of all, concerning humanitarian aid or UNHCR convoys, neither Tolimir nor the main staff of the VRS had no authorization with regard to granting approval or denying approval for the movement of these convoys in the territory of Republika Srpska. In the relevant period of time, the responsibility for granting approvals for humanitarian aid was in the hands of a coordinating body for humanitarian operations that was headed by a civilian, while the VRS exclusively had the task of providing security and checking of the convoys and to secure the routes of the movement of the convoys. The VRS didn't have an authority and didn't have any way of limiting the supply of humanitarian supply, nor did it impose any restrictions on humanitarian assistance. As for the responsibility for granting humanitarian convoys, an illustrative exhibit is D303. It is an order issued by the Chief of the Main Staff of the VRS on the 31st of August 1994, in which it is explicitly says, you know that the Main Staff of the VRS does not have any further authority or responsibility to grant the entry and the movement of the Could Mr. Tolimir please slow down?
Mr. Tolimir, I have to stop you because the interpreters are now getting difficulties again. Mr. McCloskey?
I very much apologize for interrupting, but we have in the translation the chief of the main staff. Now, there is a chief of staff of the main staff who we know is General Milovanovic, and there is the commander of the main staff, as we know, as Mladic. The chief of the main staff, as translated, is unclear who the general means, and I apologize, General, but our translators need to be able to fix that so we know whether you're talking about Milovanovic or Mladic.
It can easily be checked by looking into the document D303, but this is a typical result of the speed of your submission. Again, I have to ask you to read slowly. It's in your interest so that the chamber is in the position to receive your full and the entire oral submission. Please continue.
Thank you, Mr. President. I'm going to repeat what Mr. McCloskey has pointed out. Exhibit D303, an order issued by the Chief of the Main Staff of the Army of Republika Srpska on 31st of August 1994, explicitly says the following. So, we are talking about the chief. There was only one chief, and that was Milovanovic. And I quoted this paragraph. In Exhibit D307, the document signed by General Mladic on the 16th of January 1994 reads, and I quote, pursuant to the order issued by the President of Republika Srpska, Dr. Radovan Karadzic, Item 3 of the said order, confidential number 01-128/94, is amended in the following way. All disputes with UNPROFOR and military observers shall be resolved exclusively through command of the Corps of the main staff of the VRS, and as far as the international humanitarian organizations are concerned, this is going to be resolved through the government coordinating body for humanitarian aid. Concerning the responsibility for issuing permissions for humanitarian aid in the relevant period, that is to say from March 1995, is clearly being indicated in Exhibit P689, which is a decision on setting up a state committee for cooperation with the United Nations international humanitarian organizations, which explicitly in Article 6 says the issuing of permits for humanitarian convoys and the movement of UN personnel and that of humanitarian organizations in the territory of Republika Srpska shall be done pursuant to a decision taken by the committee and will be implemented by the coordinating body. Therefore, there is no evidence that in the course of 1994 and 1995, Tolimir was ever involved in the issues relating to humanitarian aid convoys for Srebrenica and Žepa. There is not a single document proving that that was the case and proving that Tolimir was at all involved in these matters or that he had any impact on the restrictions of humanitarian aid convoys. That was neither within the scope of his responsibility nor was it the responsibility of the VRS. The VRS's duty was to provide security for the convoys and to check them. In paragraph 211 of its final brief, the prosecution says, and I quote, despite the fact that the state committee had been set up, it was the main staff of the VRS who had final authority to impose restrictions to humanitarian convoys at their own discretion, unquote. The prosecution has no evidence to support this. On the contrary, the main staff of the VRS could not amend any decision taken by the coordinating body for the humanitarian aid as well as those taken by the committee. As said by witness Slavko Kralj on transcript page 183, when asked whether the main staff of the VRS was able to change the decisions approving the movement of convoys in the territory of Republika Srpska, he responded as follows. This document could have been amended only based on the decision taken by the organ that had originally issued it. The main staff of the VRS did not have an authority to amend government documents. The duty of the main staff of the VRS was to issue a document notifying the checkpoints about convoys that were given or denied permission to pass, which was a routine activity in which the chief of the staff or those who were entrusted with technical matters would deal with. This document in every aspect had to be in compliance with the decision of the coordinating body for humanitarian aid. In Annex C of its final brief, the prosecution makes reference to the restrictions of the humanitarian aid convoys by extracting pieces and parts of documents in which huge quantities of food and other necessities are stated as having reached the enclave. As an example of such restriction, the prosecution says cylinders of oxygen, matches, plywood, oil, lubricants, etc., which is not necessary for the life of the civilian population. However, the prosecution failed to analyze the quantities of food that reached Srebrenica and Žepa in the relevant period. From the documents that were presented to this trial chamber, it is clearly evident that considerable quantities of food and other bare necessities required for the life of civilians have indeed reached the enclaves. However, the problems with the commodities from the humanitarian aid are of a quite different nature, because the humanitarian aid was primarily used in order to supply the army of BH in the enclaves, and the priority was given to its members. This was testified to by witness PV073 on page 642 of the transcript, where he says that his son had been digging trenches for the BH army in exchange for food. All the humanitarian aid convoy problems are attributed by the prosecution to the VRS. However, during the months preceding the attack on Srebrenica, the main problem was neither the VRS nor Republika Srpska, but rather the problems that existed between the Dutch battalion and UNHCR. In the study of the Dutch Institute for War Documents, which is an exhibit P619, page 6, reads that the Dutch battalion also checked the convoys, and then it goes on to say, quote, on the 20th of June, another UNHCR convoy.
Please slow down. It's impossible to follow. The interpreters are sometimes 3 or 4 lines behind you. Carry on, please.
Čitam deo.
I'm quoting a portion of the study of the Dutch Institute. On 20th June, another UNHCR convoy arrived in the enclave, this time with 56 tons of sugar, beans, salt, fish, flour, soaps, powder milk, and biscuits. And once again, the Dutch battalion searched the convoy even more thoroughly than if it had been done by the VRS. According to the information provided by the UN military observers present on this location, the commander of the convoy objected to the inspection carried out by the Dutch battalion and informed his staff thereof. The result was that this convoy was delayed until the next day, until the Dutch battalion changed its procedure. It goes on to say as follows on page 6, that the impact of these disagreements between the UNHCR on the one hand and the Dutch battalion and Army of BH on the other was that the UNHCR convoys would be suspended for as long as the ABH army suspended or gave up on mandatory and thorough inspections. That would mean that the Dutch battalion would have no reason to conduct any inspections of the convoy. Franken was not satisfied with this. He perceived it as an attempt to put the Dutch battalion against the ABH and to make them as two confronting parties. His opinion was that the Dutch battalion certainly did not want to act in accordance with what was dictated by the army of BH, and in this case, concerning UNHCR, it is demonstrated that there was no willingness to allow the inspections of their convoys. They thought that adhering to their own principles and rules are much more important than the supply of the humanitarian aid, and they should not lay the blame on the Dutch battalion ABH for whatever happened, unquote. Can the accused please continue from paragraph 28?
Mr. Tolimir, the interpreters asked you to continue from paragraph 28 again, so that everything is on the record.
In a nutshell, on the issue of these convoys, the failure to deliver humanitarian aid cannot be attributed to the alleged restrictions put in place by the VRS or any body or organ of Republika Srpska. Furthermore, witness Slavko Kralj testified at transcript page 18406 that in the month of May of 1995, convoys were not reaching the enclave during the VRS shelling campaign. They themselves suspended the movement of convoys without having even reported to anyone the fact that they had given up on some of these convoys. They were not restricted by either the coordinating body or the VRS. Simply put, these convoys did not reach checkpoints. According to the evidence of witness Kralj, transcript page 18407, the same practice was in place during the NATO aggression on Republika Srpska in the months of September and October of 1995. Numerous pieces of evidence were adduced at trial which point to a continued practice of misuse of humanitarian aid convoys. Firstly, humanitarian aid was distributed among the members of the BH Army and was used by the BH Army in the enclaves, whereas humanitarian aid convoys were used as a means of smuggling in weapons and ammunition intended for the BH Army. Since the enclaves were getting ready to engage in the operation of joining up the enclaves with the central part of the territory. By way of illustration, the convoy that was sent to Žepa in June of 1995, a large amount of ammunition was found hidden in flour sacks. We had occasion to see video clip P2126 and exhibit D78, wherein the Rogatica Brigade reported about having found a certain amount of ammunition in the convoy traveling to Žepa. We also saw Slavko Novakovic's reports speaking about the practice of misuse of these convoys, namely exhibits D73 and D214. Speaking about the practice of using UNHCR convoys as means of supplying BH Army, are documents such as exhibits D197, D198, and D199. Let us mention here exhibit D80 only. It bears the signature of Suljo Hasanovic, chief of the Defense Ministry branch in Srebrenica, dated the 5th of June 1995, wherein the Defense Secretariat in Tuzla was
informed of the fact that a certain amount of food and fuel had been set aside for the needs of the BH Army, and I quote, after having been taken out of the humanitarian aid contingent which arrived in this area through the UNHCR, and one of the batches of aid had been received from the Dutch battalion, unquote. According to the rules of international humanitarian law, the goods intended for a civilian population may not be placed at the disposal of military units. This was precisely done in Srebrenica and Žepa. The capabilities of the BH Army to prepare and carry out sabotage and terrorist operations out of the enclaves and to work toward preparing the operation of joining up the enclaves with the central BH territory directly depended on the supplies coming from the humanitarian aid, and not only those, but also on the supplies at the disposal of the Dutch bat. Under those circumstances, Republika Srpska was entitled to restrict the use of humanitarian aid, but it had not done so. The allegation against Zdravko Tolimir that he had participated in the imposition of restrictions on humanitarian aid convoys in order to create unbearable conditions, living conditions for the civilian population is unfounded in more than one way. The issue of convoys related to the logistic supplies for UNPROFOR is quite separate from the issue of UNHCR convoys, which were intended for the humanitarian needs of the civilian population. Ever since its displacement, or ever since its deployment there, UNPROFOR and the Dutch bat in Srebrenica failed to perform their basic duties. The main duty of UNPROFOR was to demilitarize the enclave, but this had never even been attempted. Quite the contrary. The UNPROFOR forces present in the enclave tolerated the fact that Muslims were armed, had regular meetings with them, and as indicated by Exhibit P2120, even developed a plan of joint action in the event the VRS would attack the enclave. And this plan was supposed to be kept secret even from UNMOs. Now, in paragraphs 228 and 229 of the prosecution final brief, it is stated that because of the restrictions imposed on UNPROFOR by the VRS, UNPROFOR was unable to fulfill its mandate. However, the evidence clearly shows that UNPROFOR had not been engaged in fulfilling their mandate to begin with, namely the demilitarization of the enclaves, and instead proceeded to tolerate the BH Army in the enclaves, who had been arming busily and reorganizing themselves in preparation for offensive combat. The fact that the VRS wasn't the party that was making the work of UNPROFOR impossible is clearly shown by the fact that ever since its deployment in the enclave, UNPROFOR, or the Dutch bat, did not enjoy freedom of movement. This is illustrated by the so-called Bandera Triangle, where 100 Dutch BAT members were captured immediately upon their deployment there. As stated by witness Bering at transcript page 9032, we did not have actual freedom of movement. On the basis of the evidence adduced at trial, one cannot conclude that the VRS restricted UNPROFOR in the fulfillment of their mandate. Quite the contrary, the Republika Srpska Army kept alerting UNPROFOR to the fact that they had been failing to fulfill their mandate and that they had been allowing the BH Army to use the enclave as their military stronghold. At paragraph 228 of their final trial brief, the prosecution mentioned the issue of airlifts as a means of providing supplies for UNPROFOR. Exhibit P710, a telegram that General Janvier sent to Annan, and I repeat, that's P710, the telegram sent by General Janvier to Annan on the 18th of April 1995, indicates that this means of supplies would have had far-reaching consequences. The actual reasons motivating the airlifts as means of supplies were presented by General Rupert Smith in their statement given to the prosecution, D193, page 8. Therein, he states, I explained to Mladic that as an officer of the United Nations, I supported sanctions as a necessary part of the peace process. I also explained to him that the blockade of the enclave would have prevented me from carrying out the duty that I had in respect of my soldiers, which could not be tolerated and which would result in the supplies being brought in by helicopter, and that would include NATO military operations as well, unquote. All of this was taking place in the period when Muslims were busy preparing themselves for the operation of joining up the enclaves with the central BH territory. Behind all these various requests, there was the aspiration on the part of UNPROFOR to have convoys transit the Republika Srpska territory without any inspections or checks whatsoever. As indicated in the study produced by the Dutch Institute for War Documentation, P619, page 2, and I quote, Smith wanted a decision to be taken at the highest possible level with a view to ensuring a freedom of movement, rather than have that freedom depend on the circumstances prevailing or the various conditions, such as the possibility of checking convoys. And thereafter, the VRS had to be notified of the fact that, as part of the existing rules of engagement, UNPROFOR was prepared to engage in combat to protect these convoys and to call in close air support. This is P169, page 2. However, the VRS consistently complied with the procedure proposed by UNPROFOR itself. Specifically, the issue of UNPROFOR convoys was regulated under two agreements: the General Cessation of Hostilities Agreement, Exhibit P1011, and the agreement titled The Principles of the Freedom of Movement, which was stipulated at the proposal of UNPROFOR and signed by General Tolimir on behalf of the VRS and General Brinkman on behalf of UNPROFOR. This is Exhibit D77. The agreement regulated the way in which UNPROFOR convoys were to be cleared, were to move and to be checked. This agreement, however, does not apply to humanitarian aid convoys and had nothing to do with the supply of humanitarian aid of the civilian population. The witness who was best placed to speak to the issue of the way in which decisions were taken with regard to UNPROFOR convoys and to the role of Tolimir therein was Slavko Kralj. And the trial chamber should pay due attention to his evidence. General Tolimir and General Guerrero were representatives of the VRS in the Central Joint Commission, at the meetings of which UNPROFOR convoy movements were negotiated, as well as other issues relating to the freedom of movement. Tolimir did not have the authority to either approve or deny the approval for the movement of convoys. He could merely provide his opinion or the information arising from the meetings of the Joint Central Commission. The decisions were taken either by commanders or chiefs of staffs. Or, in their absence, the officer who was entrusted with that task by his commander. Tolimir and Guerrero participated in the procedure where certain requests by UNPROFOR were examined. There was evidence adduced to that effect as well, because they were members of the Joint Central Commission. This was confirmed by witness Kralj at transcript page 18281. At the meetings of the Joint Central Commission, the type of goods and the quantities of goods that may be transported were discussed, unquote. Secondly, it was proven at trial that in deciding on approvals for UNPROFOR convoys, care was taken of the quantities that are required for UNPROFOR purposes in order to allow it to operate and to have sufficient foodstuffs for soldiers. The goods that could have been used as supplies for the BH Army and that were not necessitated by the Dutch bat were not given clearance, as was the case, for instance, with large quantities of plexiglass, ski gear, and similar. On the issue of weapons and ammunition, the Dutch bat in Srebrenica and the Ukrainian battalion in Žepa were hostages of the BH Army, which was able to disarm them at will and to seize their weapons. By way of illustration, the instance where weapons and ammunition were seized off the Ukrainian battalion in Žepa, Exhibit D55, paragraph 94. Now, there is also Exhibit D105, which clearly speaks about the fact that the weapons and equipment intended for UNPROFOR could possibly also have been used for the purposes of the BH Army. This is one of the reports produced by Avdo Palic and intended for the BH Army General Staff, dated 16 July 1995, which reads, and I quote, "We have been disarming UNPROFOR as per the previously received instructions," unquote.
Drugim rečima,
In other words, there was a plan to disarm UNPROFOR. And that plan was held by the Muslims in the army of Bosnia and Herzegovina. The prosecutor's thesis that the situation involving UNPROFOR convoys contributed to the disabling of the UNPROFOR, and that's why they couldn't demilitarize the area, is at least unfounded, if not more than that. And it shows the speculativeness of the prosecutor's argument. Namely, UNPROFOR in the enclaves had enough weapons and ammunition from the moment that they arrived in the enclave. From the moment they arrived in the enclave, they did not take any serious measures in order to disarm the BIH army in the demilitarized zones. The UNPROFOR, whose duty was to demilitarize the enclave, never used weapons against the BIH army. Whatever weapons they had, they placed against the VRS on the 9th and 10th and 11th of July 1995. And in addition to that, the convoys were tendenciously used against the VRS. The true situation with the convoys is demonstrated by D304, which is a document issued by Mr. Akashi on the 1st of March 1995. That document shows the way the BIH army treated UNPROFOR. In a nutshell, in paragraph 5 on page 4, it is stated, and I quote, "First of all, the Bosnian government and Bosnia and Herzegovina are abusing the relative peace which was established after the agreement on the cessation of hostilities was signed in order to put financial pressure on UNPROFOR with regard to the agreements." I continue with the quote, "Secondly, taking into account the reorganization of the Army of Bosnia and Herzegovina and the gathering of a large quantity of forces and logistics support in the key areas, we believe that an attack is in the offing and that attack could be launched as soon as the weather conditions improve. Thirdly, the intention of the government, inter alia, is to convince the international community that the agreement on the cessation of hostilities is not functioning, and in that way they want to discredit the Bosnian Serbs. As a matter of fact, the Bosnian government is the one which has caused more problems because of the introduction of new restrictions on the freedom of movement, and that's why they refuse to attend the meetings of the Joint Commission. That is why UNPROFOR has reached a stalemate, and the problems cannot be resolved in an adequate way through the work of the Joint Commission. On the other hand, the restrictions that the Serbs have introduced have been largely weakened, although they are still in charge and they still control the delivery of fuel into the enclaves, unquote. The prosecutor speaks about the alleged participation of Tolimir in the restriction of unprovoked convoy in paragraph 60A and portrays that involvement as an attempt to create unbearable conditions for the civilian population of Srebrenica and Žepa. This allegation is completely unfounded, since unprovoked convoys did not have anything to do with the position of the civilian population in the enclaves of Srebrenica and Žepa. The prosecutor points out that the goal of the VRS was to create unbearable conditions for the population of the enclaves of Srebrenica and Žepa. However, among a multitude of evidence which prove that this was not the goal of the VRS is also a statement by Major Franken that he provided to the prosecutor. This is a P607, which says inter alia, quote, during that period, the Serbs proposed to the Muslims to trade with them at the prices that prevailed in the black market in the enclaves. After several rounds of negotiations, the civilian authorities of the enclaves allowed the Serbs to supply the enclaves. We insisted that the goods should be sold at the market price, or what would have been the market price, and that the Dutch battalion should not have any commercial role in that, unquote. This fitted well within our own idea of normalizing a relationship among the warring parties. Very soon, a rumor spread that initiative did not bode well with the groups that control the black market. The local military authorities stated that the ban came from the top echelons of the military leadership, although those or similar things functioned well in Gorazden. I suppose that the initiative to boycott the trade actually came from the military leadership in the enclave, unquote. The proposal that was made by the Serbs with regard to establishing a trade relationship with Srebrenica is completely contrary to the prosecutor's thesis and allegations that there was an intention to create a totally unbearable conditions for the population of the enclave. One of the contributions in the alleged joint criminal enterprise regarding the expulsion from the civilian population from the enclaves is the operation which was carried out by the 10th Sabotage Detachment on the 23rd June 1995. In paragraph 890 of the prosecutor's final brief, the prosecutor proposes a totally uncorroborated allegation according to which, and I quote, Tolimir approved the engagement of the 10th Sabotage Detachment in the implementation of terrorist activities against the civilian population of Srebrenica with a view to making the living conditions in the enclaves unbearable, unquote. Could the accused please be asked to slow down when reading?
Sir Tolimir, I have to stop you again. The interpreters asked that you slow down while reading, and you are all the time reading your own text and the quotations. Please bear in mind that many people have to follow. Slow down, please.
Hvala, gospodine predsjedavajući.
Thank you, Mr. President. I apologize to the interpreters. First of all, besides the fact that the facts are unfounded, the prosecutor did not include that in the indictment. In that operation, or rather, Colonel Salapura testified about the operation by the 10th Sabotage Detachment. He was engaged in the preparations for that operation, and he testified that it was a diversionary operation that did not have any consequences, and that implementing that diversionary action was just an admonishment to the forces in Srebrenica not to take action against the VRS. End of quote. First of all, there is no proof that Tolimir approved that operation. Indeed, there could be no evidence to that effect, because Tolimir was not in a position to either order the use or use the 10th Sabotage Detachment. That detachment was an independent unit of the main staff of the VRS, which was directly subordinated to the commander, i.e. to the Chief of Staff. That military operation had not been directed against the civilian population, which is clearly demonstrated by P2200 issued on the 21st of June 1995. That document was signed by Colonel Salapura, and this document speaks about the use of the 10th Sabotage Detachment. The 10th Sabotage Detachment was provided clear instructions in paragraph 1, and I quote from that paragraph: to collect data, to plan and to implement the task. The person responsible for all that is the commander of the 10th Sabotage Detachment and the Chief of the Intelligence Department of the Drina Corps. In paragraph 6 of the document, it says, when implementing the task, strictly adhere to the following. UNPROFOR members should not be threatened, avoid inflicting casualties among the women and children, unquote. This document shows that the prosecutor's allegation about that operation is completely unfounded, and that its objective was not to attack the civilian population or to intimidate it. That diversionary action was not an attack against the civilian population, which is also corroborated by a report by Ramis Bečirović, who drafted it on the 27th of June 1995, and which says that nobody was hurt during that operation. If anybody had been hurt, Ramis Bečirović's report would have certainly contained that information. In any case, nothing is said about Tolimir's actions in the third amended indictment as Tolimir's contribution to the alleged joint criminal enterprise, and that's why this operation by the 10th Sabotage Detachment is not relevant when it comes to considering Zdravko Tolimir's criminal responsibility. The prosecutor regards the attack against Srebrenica unlawful. For example, in paragraph 259 of the final brief, the prosecutor says, quote, the attack against the Srebrenica enclave had two legitimate military goals.
to achieve the demilitarization of the enclave and thus disabling the 28th Division from launching attacks from the enclave, and to completely cut the contact between the two enclaves. However, creating unbearable conditions for the population of the enclaves constituted the violation of the international laws. End of quote. Moreover, by interpreting General Smith's testimony, the prosecutor states, and I quote, that the attack against the enclave was not the only choice for the VRS, unquote. The prosecutor erroneously states that the goal of the Kriva 95 operation was to create unbearable conditions for the population of Srebrenica, whereas he never mentions the real reason for attacking Srebrenica. Or rather, he mentions the real attack against Srebrenica. The attack that was launched on the 6th of July 1995 was the only possible solution, primarily because of the fact that the BRH army had carried out operations to link up the territory of the enclaves with the central part of the territory during the period of time when the all-out aggression against the territory of Republika Srpska was being prepared. If the VRS had not carried out an attack against Srebrenica and Žepa in the following months, it would have faced offensive operations at several fronts.
It's now over 15 minutes before 4. It's time for the first break, although we started a little bit later, and I think it would be a convenient time for our first break, for your benefit and for the benefit of the interpreters. I would kindly ask you to make sure, together with Mr. Gajic, that all interpreters have the text of your submissions, and also the court reporter should be provided with one copy. We adjourn and resume 4:15.
All right, we will be